The record, Mr. Brooks has been removed to the other courtroom. The jury is not present, and the witness that was on the stand is also not present in the courtroom.
Actually, he is, Judge.
Oh, all right, then we'll have
step him out.
him removed. Thank you. Thank you for that clarification. I didn't see him seated all the way back behind a couple of individuals. So this morning, Mr. Brooks, prior to the court removing him, had interrupted the court approximately 10 times prior to 10:19 a.m. Then, of course, he was removed. This does not include the repeated commentary, either under his breath but still audible for the court to hear, the jury to hear, and witnesses to hear, related to a variety of topics, including subject matter, jurisdiction, misconduct by the court, disapproval with the court's rulings. This very last witness was a witness called out of order at the request of Mr. Brooks. As I know the attorneys are well aware, and certainly this court is well aware, under 906.11, the court shall exercise reasonable control over the mode and order of interrogating witnesses and presenting evidence so as to do all of the following: make the interrogation and presentation effective for the ascertainment of truth, avoid needless consumption of time, protect witnesses from harassment or undue embarrassment. That's all under sub 1. Sub 2, scope of cross-examination. A witness may be cross-examined on any matter relevant to any issue in the case, including credibility. In the interest of justice, the judge may limit cross-examination with respect to matters not testified to on direct examination. I frankly haven't exercised my authority under that particular subsection. I have generally relied upon sub 1. In addition, sub 3 says the following: leading questions. Leading questions should not be used on the direct examination of a witness except as may be necessary to develop the witness's testimony. Ordinarily, leading questions should be permitted on cross-examination. And during the cross-examination of this last witness, Mr. Brooks objected almost without fail, if not without fail, to every single question asked by the state on grounds of either leading or relevance. And then when the court overruled the objections, as time went on, it seemed to me that his commentary became much more audible. He was muttering under his breath and clearly showing disrespect for the court and the proceedings. In my opinion, they're baseless objections. Again, because this witness was brought into court on a subpoena that was from Mr. Brooks, served, of course, by the state to assist with him in that regard. But the state was well within its rights to ask leading questions. It's this court's opinion that the repeated interruptions by way of baseless objections is to disrupt these proceedings, disrupt the testimony of the witnesses, and in particular, Mr. Marquez. This court has been abundantly patient this morning, noting the repeated interruptions by Mr. Brooks, starting right away at 8:31. There were a couple of interruptions, continuing at 8:37. At 8:48, I think we had a total of 5 more at that point or so. At 8:49, and then, of course, at 10:19, this court removed him under its authority in Illinois versus Allen. I also had warned him, or at least at times I would give the jury an admonishment, not really an admonishment, but an instruction: please disregard the commentary by Mr. Brooks. It's been very apparent that any time this jury is brought in or taken out, Mr. Brooks begins making statements that are misstatements of the law, or generally his disagreement with whatever is going on at that particular time, accusing the court of either bias or misconduct, accusing this court of hiding information from this jury. This court is not doing any such thing. I will make a finding that based upon the conduct of Mr. Brooks, that he has forfeited his right to be present during the cross-examination and any redirect of Mr. Marquez. Mr. Brooks's conduct has been anything but respectful today. Again, it's been disruptive. As this court was stepping off the bench, he made some type of statement about contempt. Are you finding me in contempt? This court is well aware that one of the permissible ways to handle a defendant who shows flagrant disregard in the courtroom for elementary standards of proper conduct is to find a defendant in contempt. However, I'm not dealing with a defendant who is out of custody. I'm dealing with a defendant who is in custody on very serious charges, including, if convicted, facing the possibility of life sentences without the possibility of extended supervision. It is my opinion that finding him in contempt is not really a viable alternative to this court. Frankly, it would, in my opinion, it would serve to give the defendant, let me restate that. In my opinion, if this court were to find Mr. Brooks in contempt, it would allow him to profit from his own wrongdoing because it would result in a delay of these proceedings. I would have to, of course, make certain findings. One of the possibilities for contempt is to hold him in custody until such time as he's willing to abide by the rules. That is just not something this court is willing to even do because it would delay the proceedings. I am aware that that is a option identified by the Supreme Court in Illinois versus Allen, but I would remind the parties once again that Illinois versus Allen was decided in 1970. Certainly the technology that we have available in this courtroom was not something available to the parties in Illinois versus Allen. We have a very new state-of-the-art courthouse that I am operating out of. I'm in courtroom 13. Next door is courtroom 20. These are just the room numbers that I'm referring to. As you can see, we have the ability to see and hear into that courtroom, and that courtroom has the ability to see and hear into ours. I will confirm with the bailiff and the clerk that the audio is working. I'm told that it is from my clerk. If I could also get verification from the bailiffs who are in that courtroom. But we have the ability, I have the ability, through that technology for Mr. Brooks to meaningfully participate. He does have, and it was provided with him when he was taken to that courtroom, the objection sign. I also instructed that he be given a pad of paper and a writing utensil so that he could write down his objections. Or if I feel it appropriate, I can unmute and hear what his objection is. But it's my belief that the use of my ability to mute and unmute will assist the proceedings so that it's orderly, that it is free from disruption as best as I can control it under my authority under 906.11 and my authority given to me and expressed by the U.S. Supreme Court in Illinois versus Allen. Although I'm making a finding that he's forfeited his right by his conduct to be present for the continued cross-examination and any redirect of Mr. Marquez, I'll also make an alternate finding that the technology that I've just described provides the functional equivalent of Mr. Brooks being present during this case. With that, I would like to have the jurors brought in. I'll have the witness brought back to the witness stand with the assistance of the interpreter. and the state can continue with its cross-exam of the witness called out of order, but on behalf of Mr. Brooks. And I am getting verification from the bailiff in the other courtroom through my bailiff here that the audio and video is working as it should. Would also like to point out that there are headphones at the table in front of Mr. Brooks should he choose to wear them. He has not worn them in quite some time. Previously made reference to needing it when he was in the other courtroom, so they are there and available. All right, would Mr. Marquez and Interpreter Ryan please take the stand, and we'll have the jury brought out. And just for the record, I will certainly let Mr. Brooks know he can ask to come back in when he's willing to abide by the rules of decorum and courtesy. The record should reflect the jury is being brought back in. Thank you, everyone. Please be seated. The record should reflect that Mr. Brooks is appearing from another courtroom. That should not affect the jury's verdict in any way. The state may continue with its cross-exam of this witness.
The state would have nothing further.
All right, Mr. Brooks, do you have any redirect for this witness? Mr. Brooks, do you have any further questions for Mr. Marquez? The record should reflect that Mr. Brooks is reading out of a book. He has not answered the question. I will ask one more time. Sir, do you have any further questions for Mr. Marquez?
Am I unmuted?
You are. You have been.
What's going on?
Do you have any redirect questions for Mr. Marquez? This is your opportunity to ask any follow-up questions that you have for this witness.
Say something. I'm trying to see if the headphones on. Can someone say something from the other courtroom?
Any questions for Mr. Marquez at this time? It's your opportunity to ask follow-up questions. The state indicated it did not have any additional questions.
Nope, I don't got no follow-up question.
All right, thank you. Then, Mr. Marquez, you may step down. Thank you for being here today. All right, I need to excuse the jury momentarily. Please rise for the jury. Mr. Brooks, under Illinois versus Allen, which that case clearly tells me to do that, once lost, the right to be present can, of course, be reclaimed as soon as the defendant is willing to conduct himself consistently with the decorum and respect inherent in the concept of courts and judicial proceedings. The court is going to continue with the direct examination by the state of Detective Carpenter. I would like you to come back to this courtroom. Are you willing to conduct yourself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings?
I didn't do anything to be held in contempt in the first place.
So are you willing to abide by the rules of decorum and civility? I would direct your attention to SCR Chapter 62, which has been provided to you previously.
Does that say anything in there about me being held in contempt?
That does not, no.
So why have I been held in contempt?
I didn't hold you in contempt, sir. You are simply in a different courtroom based upon your disruptive behavior. I'm giving you the opportunity.
Has not been disruptive.
I've put my findings on the record, sir, and the record stands in that regard. I'm giving you the opportunity, if you can, indicate to this court that you will conduct yourself with courtesy and decorum Are you willing
So-
to do that, sir?
Is Your Honor willing to tell me why I've been held in contempt?
I did not hold you in contempt, sir. I've already indicated that.
Removing me from the courtroom is like holding me in contempt.
I didn't hold you in contempt. You were removed pursuant to the authority given to me by the United States Supreme Court in Illinois versus Allen, based on your disruptive behavior.
My behavior wasn't disruptive, Your Honor. The record should be corrected in that. And as I recall you stating before, or not you stating, but us having a conversation about Illinois versus Allen, for the record, at one point, I got the date in my notes that we had it, where I said on the record that there were three options identified. And
Mr. Brooks, I'm not going to have a debate with you on what the law means and whether you understand it or not. I'm simply asking you whether you are willing at this time to abide by the standards of courtesy and decorum that are outlined in SCR Chapter 62 and that are inherent in the concept of courts and judicial proceedings, including making proper objections based upon the rules of evidence, based upon the rules of procedure, based upon the law, that you will not interrupt when you disagree with a ruling made by the court, and that you will generally conduct yourself with dignity and decorum.
But is it
Willing
not
to
my
do
right?
that?
Is it not my right to object?
I'm going to ask Mr. Brooks one more time if he would like to come back to this courtroom and if he's willing to conduct himself with dignity, respect, and decorum.
But for the record, I don't consent to being called that name, and I never stated that I wanted to be removed from the courtroom.
All right, I'm going to mute Mr. Brooks. He is clearly not answering my question. And given his recent conduct, I'll indicate he continues to forfeit his right to be present based upon the prior disruptive conduct. I have given him 3 opportunities to answer the question, would you like to come back into the courtroom? And in other words, to reclaim his right to be present. He has chosen not to answer that. I understand he disagrees with the characterization by this court of his conduct, but my ruling stands and the reasoning for my ruling stands. What I will advise Mr. Brooks is once the jury is brought back out and once the witness is back on the stand, I will unmute him so that he can properly object. And then I'll rule on, of course, any objections. I certainly reserve my right to use the mute function of the audio-visual capabilities that I have should that right be abused. So with that, why don't we have Detective Carpenter come on back to the stand. The jury is advised to come out.